Welcome to Letters of Intent, the podcast for deal makers and risk takers. I am Pankaj Raval, founder of Carbon Law Group, and today we're jumping into something that's got real-world implications and that everyone's talking about, and that is tariffs.
That's right. I'm Sahil Chaudhry, associate attorney at Carbon, and this isn't speculation anymore. As of April 5th, 2025, the new Trump tariffs will have officially gone into effect. A universal 10% tariff will now apply to all imports into the U.S., with additional country-specific tariffs, like 34% on China, 20% on the EU, and more, rolling out this week.
So let's break it down, Sahil. So this is the biggest trade action since the 1930s. This is crazy. The universal 10% tariff means that every importer, regardless of origin or industry, is now paying more to bring goods into the U.S. than pretty much ever before.
And if you're importing from China, India, the EU, or Japan, those tariffs are stacking on top. For example, goods from China are now subject to a total 54% tariff. That's a huge margin killer.
That's crazy. Yeah. I mean, we're just seeing this. I know everyone saw that image of Trump holding up that board during the press conference talking about, okay, these are the reciprocal tariffs that he's going to be essentially enforcing as of April 5th. But, even without it going into effect yet, we see the markets are in turmoil. We're already seeing supply chain and panic and the stock market reacting negatively. And this isn't just a policy move. It sounds like this is a full-on economic shift. Businesses that don't move fast are going to feel it hard.
Pankaj, I'm already talking to our clients about this because imagine you've baked in your profit margin and imagine if you've already got a PO that's already in effect, that's effectively a contract. Now, when these tariffs kick in, it's just eating into your margin. And a lot of small to mid-sized businesses are running on very thin margins that rely on volume. But if you have a tariff that is increasing to something like 54% now with China. China had 34%, but that's on top of their already 20% tariff. That's a huge change in how you plan your business. So it's really important to understand these tariffs because they're going to have real world implications. I mean, from a big picture perspective, I think perhaps the Trump administration is bargaining here to get the reciprocal tariffs reduced by other countries. But in the short term, this is going to hit small to mid-sized businesses hard. And we want to be there for our clients to figure out how do we navigate this.
Yeah,
So
absolutely.
I want to start with just an understanding of where does this power even come from? So you have Section 301 of the Trade Act of 1974, which allows for retaliating against unfair trade practices. That's what this tariff measure is. You have Section 232, which permits tariffs for national security related matters. You have Section 201 that's intended to safeguard domestic industries. Now, these give the executive branch broad authority, and courts have historically upheld it, which means you don't need Congress to vote in favor of the tariffs. It's a huge power the president has.
Interesting. So it means businesses essentially can't litigate their way out of this. They need a protective strategy, not just courtroom hope, is what you're saying?
Yeah, exactly. This is not something that actually falls squarely in our wheelhouse, which is this is a contract matter now. This is negotiating. And our clients are going to have to think about, okay, well, let's say you're an importer and you're selling to your customers here, and you're also buying from your suppliers. So there are two ends of this spectrum here where you may need to negotiate with your supplier to take this tariff into account. And then you may need to ask your buyer to pay a little bit more in order to accommodate the tariff. So there's a negotiating and business component, but then there's also a contract component. And before we get to the contract component, there are some potential narrowly tailored regulatory exceptions that could help. They're tough, but they could help. There's, for example, the Section 301 exclusion. If your product is on the tariff list, but qualifies for an exclusion, you can get temporary relief from the tariffs, retroactive refunds on duties that have already been paid, and exemptions that apply to all importers of that product. Now, here's the kicker. In order to qualify, you need to show that there's no viable U.S. supplier, that there is significant economic harm, and that the product isn't tied to sensitive strategic sectors. So even if the next application window isn't open yet, clients should start to get the paperwork ready and the economic data ready now so that they're ready to apply for this kind of exclusion.
Interesting. Interesting. That's really interesting exclusion you brought up. I mean, there's an interesting exception to these tariffs that I think a lot of businesses are going to be interested in learning about. Because if I'm producing clothes, if I'm a clothing manufacturer and I'm producing in Bangladesh, it's a big question. Is there a viable U.S. supplier of those clothes?
Exactly.
Is there significant economic harm if I can't import from them? And it doesn't sound like clothing would be tied to sensitive strategic sectors. What does that mean for cosmetics? What does that mean for a lot of industries that we work with? So I think this is going to be, there are a lot of questions that this brings up, but I think super helpful to learn more about this Section 301 exclusion.
And then that takes us, to who pays the tariff.
Right, exactly. Yeah, who does pay the tariff, Sahil?
So it comes down to Incoterms, which is this international norm. These are the international business norms that govern these types of transactions. So, for example, you've got two main concepts. One is FOB, which is free on board, where the buyer takes ownership once the goods are loaded onto the ship. You, if you're the importer, you pay the shipping, insurance, and the tariff when the goods arrive. The second option is CIF, cost, insurance, and freight, where the seller pays for shipping and insurance to the US. But if you're the importer, you still are paying the tariff because the importer of record is on the hook at customs. So either way, whether it's FOB or CIF, if you're the importer of record, you're paying the tariff, period.
Interesting. If you don't have these clauses in your contracts already, it sounds like you need them probably yesterday. What do you do?
So basically, there are ways that you can apply for a regulatory exemption, but those are that's basically temporary relief. I mean, we want to advise our clients with how do you plan long term for this? And one way that we can do that is by negotiating contract clauses. For example, there are 3 important contract clauses that you would want to negotiate for in this new Trump tariff era. Number 1 is a tariff adjustment clause. So if tariffs or other duties are imposed or increased by a government authority, the seller reserves the right to adjust prices accordingly. So that way it's kind of like a loan with a variable interest rate, right? It's like, okay, if there's a tariff imposed, we're allowed to increase the price. And this lets you increase the price without breaching the contract. The second is called a force majeure clause. So, for example, normally force majeure clauses include things like an act of God, natural disasters, but you can include changes in trade laws, imposition of tariffs, or governmental action that affects the cost or availability of goods. Most clauses don't cover trade policy shifts, but you can negotiate for that clause. The third type would be a change in law clause. So let's say there's a change in law that significantly increases the cost of performance. The parties will agree to renegotiate in good faith. This gives both parties an escape hatch without triggering a contract fight.
Interesting. Okay, so this is great if you're contracting right now, but what happens if I've already signed a contract and the quote is accepted, the PO is in? Can you still increase the price based on these changes?
Well, it's tough, but it's not impossible. And that's where the Uniform Commercial Code comes in. If you're selling goods, and most of our listeners who are in this business are importing or distributing goods, the UCC gives you 2 legal tools to work with. One is UCC Section 2615, practicability. If a government action like a sudden tariff hike makes performance commercially impracticable, and that change wasn't foreseeable, you may be excused from performance or allowed to adjust your obligations. But it's a high bar. Courts only grant relief if the cost spike is substantial and truly outside the seller's control. Then we've got UCC Section 2209, contract modification in good faith. This lets you modify an existing contract without new consideration, as long as it's done in good faith. So if you can show that the tariffs increase your cost after the deal was signed, you have legal grounds to approach the buyer and renegotiate the price.
Interesting. That's super helpful. That's super helpful to know, because I think a lot of sellers are probably feeling the pinch right now. They're probably unsure of what to do. Having that insight is, I think, super helpful.
If you're a small business owner, you're a small to mid-sized business owner, you probably aren't aware of these rules. And then you also don't have the wherewithal to do the paperwork, the contract drafting, the filing of the forms here to execute on these strategies. And I don't think any business owner really should expect that they have the wherewithal to do that. And I do think that's where we come into play.
Right. Absolutely. Absolutely. It's a big question, and I think also you don't want to burn bridges, right? I mean, these are suppliers. These are people who are probably doing business together for some time and want to continue those relationships. But the reality is this is going to really cut into margins for sellers and buyers potentially based on who's paying the tariff. It sounds also that you can't just like throw these objections or these issues in last second, right? I guess it probably works best when you probably make sure you want to document it, right, in the original quote date. You want to point to the date when the tariffs were enacted, and then maybe also have your team make sure that gives client notice of the change as early as possible. Anything else that you recommend to do that would help people take advantage of some of these nuances in the law to adjust pricing or cover themselves based on these changes in tariffs?
Yeah, I think our clients who are importers need to negotiate for a clause in your terms and conditions that covers change in law or tariff impact. But even if you don't, if you're not able to, we do have this UCC option that gives you a narrow path to adjust the deal, especially if you act fast and you document everything.
That's good to know. People can't really sit on this. They can't like bring it up in a month or two. They've got to bring it up now.
Right, exactly. And so if we were to propose an action plan for our clients who are importers, I would say review all your contracts for pricing flexibility. See if you've got any terms that could connect in terms of a force majeure or a tariff adjustment clause. And if you don't have that, it's a good idea to include that. Two, identify the HTS codes and country of origin risk. So each of these tariffs is classified under an HTS code. So you want to first make sure that your goods are actually classified under the lowest tariff possible. And number two, you want to evaluate what's your risk based on the country you're importing from. And you're going to have to start those negotiations with your suppliers and your buyers.
Absolutely.
You need to do an audit of your Incoterms in every purchase order, and you need to prepare a 301 exclusion package. If you're importing at scale, you want to get that temporary relief that the government is able to offer if you're importing something that has no viable substitute in the US. And maybe it's time to reevaluate your supply chain. There may be some countries that are better in terms of the tariff rates where you could shift your production and get a better tariff rate. For example, nearshoring. If you compare the tariff rates on China versus Mexico, Mexico is probably a better option if it becomes viable as a supplier.
Really interesting. Really interesting. Man, there's probably going to be a lot more to talk about here. There's probably going to be a lot more questions as we learn more about how these tariffs come into play. So if you're not sure where to start, reach out to us. We'd love to chat more about this. This is what we do. This is how we help clients. We are a global law firm that has helped clients all around the world deal with these issues, and we'd love to help you if you're struggling with trying to sort through this somewhat mess of a new regulation that the Trump administration has come out with. With that said, we have wrapped today's episode of Letters of Intent. It's a special edition talking about the recent tariffs that have just been put forth by the Trump administration and will be coming into effect tomorrow, April 5th. This is the podcast for deal makers and risk takers. We live in a world of risk, and if you are a deal maker, if you're in business trying to do transactions, you're our client. You're someone we would love to work with or at least talk to and see how we can help you. Just know the Trump tariffs are real. They are hitting businesses hard, but also there are tools, strategies, and legal levers you can pull to stay ahead of the game.
If you found this helpful, subscribe, leave a review, and share this episode with someone in your network who imports product or negotiates supplier agreements. We'll be back next week with more legal insights for founders and operators who play to win.
Thanks so much, Sahil.
See you next time.
See you next time.